People often ask, do I have to speak to the police? The answer is no. The U.S. Constitution provides that you do not have to talk to the police. No person can be compelled to give evidence against themselves, according to both the U.S. and Maine constitutions. This is what's sometimes called the Miranda. The police have to give you a warning that you don't have to talk to them before they ask you questions. And if they ask you questions and don't give you the Miranda warning, and you're in custody, your questions could be excluded. There are several scenarios that are commonly encountered when analyzing whether somebody's statement can be used. If you are not in custody, but you voluntarily answer police questions, generally speaking, the answers to those questions will be allowed. If you are in custody and you have been given your Miranda warnings, your answers to those questions after the Miranda warning will generally be allowed. If you were taken into custody but not given your Miranda warnings, and the police ask you questions and you answer, those answers can be the subject of what's called a motion to suppress, to challenge your answers to those questions being excluded from the court. If a police officer approaches you at your home or on the street and you're not in custody and they don't give you a warning, but you agree to answer their questions and do so, your questions can be used against you in court. People often come to see me saying, I answered their questions, but they didn't give me the warning. The problem is that quite often these people just voluntarily answer the questions without being in custody.